On the record in the matter of credit acceptance versus Ashley Brown, 22-013536 GC. Appearance, please.
Good afternoon, Judge. Francesca Servi for plaintiff P87205.
Okay, you're Ashley Brown?
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research, and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail, and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice of that.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, her admitting in court that she got it. So a plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rules to notify me to. I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand. I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So the court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with, you're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is you said that it was not issued or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak. I'm sorry.
That's correct. Yes.
So when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. Like how am I supposed to respond to a garnishment if I don't have this, if I wasn't served?
Ma'am, you were served with the lawsuit in this matter, correct? And then you appeared before me back in December 1st, 2022. There was a joint pretrial statement that was completed. After that, you receive your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You failed to appear. Default judgment entered against you
I did not
because
get
you failed
notice
to
is what I'm
appear.
saying.
You failed to appear. You knew you were being sued. You were properly on notice that you were being sued, and the court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed. So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, once you fail to appear, a default judgment entered against you, and the court then sent a notice of a default judgment to that same address.
Did not receive that.
So the court itself sent multiple notices to the address on file notifying you A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside. But you never did that, and that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since October 12th, 2022.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if they was lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't understand, like I said, how I'm supposed to respond, because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because, like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notification sent to me. How am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.
I don't know what you mean. How are you supposed to respond to a garnishment?
Like with this objection, like I'm objecting to it, I'm responding to it. I did not receive notice of those prior things, and I've done research on this company. This is not the first time they've done stuff like this.
Right, but I recognize you're objecting to the garnishment, but you're not providing the court with a objection that the court can consider. The court rule tells you what objections you can use. There are no such thing. There's no such thing as a hearing. There's no such thing as a hearing for a writ of garnishment. You don't get a hearing for that.
I was referring to the hearing, like I stated, that was the judgment hearing. I did not receive notice of that hearing. That's the hearing I was referring to.
Okay, that same
if I had received notice of the judgment hearing, I would have appealed.
You cannot continue to talk over me. What I'm telling you is that same court rule tells you that you cannot use an objection to garnishment to attack the underlying judgment, which is what you're trying to do.
And I understand that, but what other premise can I go on if I don't have any notices? If I had gotten those notices, I could have objected earlier. That's my whole
What I'm telling you, you cannot object to a garnishment so that you can attack the underlying judgment. You're saying the reason why you're objecting is because you did not get notice of the hearing in which you got a judgment for.
But it says that they have to serve you with these garnishments.
No, the court rule says you can't do that. It says that you can't do that.
So there are no rules saying that they have to serve you with the garnishment. Is that what you're saying?
It says the garnishment has to be properly issued, and it was.
But I wasn't served it, is what I'm saying. So how was it properly issued?
They don't have to serve you with the garnishment. They have to serve your employer.
Okay, so I don't understand then how somebody is supposed to respond if they don't have the information.
No, you were supposed to respond to the lawsuit, not the garnishment.
Ma'am, and I have already stated I did not even receive a notice for the second hearing.
But you can't use you can't object to the garnishment now.
We wouldn't be here though if I had received that notice.
The court rule is very clear. You cannot object to the garnishment to now attack the underlying judgment. Do you understand that part?
I understand that, but I'm saying if I
So why do
didn't
you keep
notice about the
repeating that
initial
then?
hearing,
Why
then
do you keep repeating the same thing?
because I'm trying to get you to understand that it doesn't make sense to say that I can't attack the garnishment if I was never properly notified about the initial hearing. There wouldn't be a garnishment if I had been notified.
I'm going to terminate this hearing if you don't let me explain this the last time. I don't have the issue of the misunderstanding. I know the court rule very well. The court rule very clearly states you cannot file a motion to object to a garnishment because you want to now argue that you missed a court date or you didn't get notice that had to do with the judgment. That's what the court rule says. So you are trying to say that you didn't get notice of the court date that you were supposed to appear for back in March of 2023. The court rule says you can't use an objection to garnishment to do that. I didn't make the court rule, man. That's just what the court rule says. Do you understand that?
Yes.
So
Judge, can plaintiff respond?
You have not provided the court with a reason under the law that I can grant your request to object to the garnishment. Yes, ma'am, you can respond.
Okay, just to correct the record, Your Honor, it was actually a summary disposition judgment that was entered in 2023, and it was also entered pursuant to the notice of 7-day rule for entry of the order. So defendant had notice to appear for that hearing through plaintiff's notice of a hearing. They had an opportunity to object to the entry of the summary disposition judgment. They didn't file a response to plaintiff's motion for summary disposition judgment. And as Your Honor had already stated, it's not a proper objection to writ for garnishment when you're attacking the validity of the underlying judgment under the court rules. So it's plaintiff would ask that you deny the objection is invalid and appreciate that you've done that.
I'm trying to explain so that the Ms. Brown can understand her concern, because I'm not saying that there's no other avenue for you to go and try to figure out what happened with your notice, or according to what they filed, you were served with a notice for your date to appear in court. And outside of that, you knew you were being sued. And so when you appeared in my court in 2022, there shouldn't be a next appearance 3 days later, or 3 years later, that is. You should have appeared at some point wondering what was going on with your case because you knew you were being sued. And they had served you with discovery. They had served you with a summary judgment motion, which the court told you when you saw us would have a deadline date. And so we advised you of that when you were last here in 2022. When you didn't respond until this objection. And you can't now attack the judgment because the court rule says you can't do it this way. And so I have to deny your motion. Okay?
Mm-hmm.
Okay, so if you want to, I don't know what the balance is on the debt. And I know you said that you had some other garnishments that took place. You could try to meet with Ms. Servey and see if you all can work something out and maybe enter an installment payment agreement or another kind of settlement agreement that will prevent them from trying to garnish your wages. So if that's what you want to do. I could put you in the meeting room now for that purpose, to see if you can come up to another arrangement so that they won't be garnishing your wages.
Okay, let's do that.
Okay.
Yep. Okay. Go! Will you hand me my screen box?
Now go.
Melrose 10 LLC versus Virgil Pulley.
Melrose what?
I don't know, what is it, Melrose 10?
Melrose 10. Yes.
Melrose 10 LLC. Case number 25-06535, Melrose 10 LLC versus VSH Enterprise and Virgil Pullins.
Good morning.
What's today's date scheduled for, please? Since I don't have a docket.
A trial.
I have for a non-payment of rent, I guess.
The last time we were in court, this was the date and time set for the trial.
All right. Well, let's see.
Good morning, Your Honor. Jahan Williams appearing on behalf of the plaintiff. I also have a representative for the landlord. Please state your name for the record.
Mark Lansman.
All right. And so last time we were here was back in August 7th. Mr. Pullins did appear. And apparently they tried to negotiate something and didn't work out. So today would be, I guess, the date for a trial, and Mr. Pullins has not appeared.
Mr. Pullins is here, Your Honor, but he does not have counsel with him.
Okay, let's see. Where's Mr. Pullins?
Right here, Your Honor.
All right, put your name on the record, Mr. Pullins.
My name is Virgil Pullins.
All right, and let me ask, before we get started with this, is there anything else pending, Madam Clerk?
We have a motion to reinstate and Ms. Caprice McKenna has came back up.
Okay, because I was under the impression that it doesn't say trial on the docket. It simply says it's a non-payment of rent case. So I can start it, but I don't know what the other thing is. Maybe we can get it finished before we start this. All right, and my understanding, of course, is that this is a trial date, except for today. And my clerk has given me some information indicating that you're not ready to go, Mr. Pullins?
Well, Your Honor, I had counsel and unexpectedly, he had to withdraw because of the trial. So I had seeked for new counsel. And I am in the process of hiring someone else, but they were not available for today's date. So they told me to come in and still do. Because I needed to be represented.
But she's gonna be representing you and VSH Enterprise?
Correct. He sent me I see a notice of withdrawal, I think sometime middle August, I got it. So,
Who sent you that?
previous attorney out.
He didn't ask the court to withdraw?
Yeah, I got a copy here.
Did he?
I'm assuming, yes.
Did I sign off on it?
May I respond, Your Honor?
Well, no, I don't think so, but, it is a court form, so I don't know if you guys got a copy of it. But actually, I brought my copy just in case.
In order for him to be released, I have to sign it, but go ahead, counsel.
Your Honor, last time we were in court, which I believe was the beginning of August 7th, 2025. Mr. Pullins was represented by counsel. He disputed at that time the ledger and you set this matter for trial. At that
Right.
time, his I heard his counsel telling him you need to be represented. His previous counsel had filed a limited notice of appearance.
Oh, is that what it was? Okay. Then he's okay.
To just handle that previous hearing and the previous proceeding. And after that, he withdrew from representation. We communicated with him. We were aware that he was going to withdraw. On August 14th, Your Honor, my office sent Mr. Pullins notice that we understood that his counsel was withdrawing, that he needed to have counsel present for today's trial hearing. And he did not respond to that notice. So he's had ample time to get counsel prepared for this hearing. My client flew in from New Jersey to be here for the trial. And at this point, we believe this is another stall tactic by the defendant to remain in the premises. And we're asking for this matter to not be delayed further. And so that we can get possession of the property and proceed with eviction proceedings. And I have a copy of the letter that we sent to Mr. Pullins that I can provide to your clerk.
When did you send that?
August 14th, 2025, Your Honor.
August 25th?
August 14th, 2025.
14th of 2025.
So approximately 1 week after the previous hearing.
Well, Mr. Pullins, why didn't you have a lawyer? The last lawyer already withdrew and you knew that. So regardless of whether plaintiff's counsel gave you notice or not, you already know he wasn't gonna be here.
That is correct. However, I never got that notice.
You never got one notice.
Notice that, that the attorney said they sent to me. I never got that. But just even further moving forward, I knew to immediately hire another attorney, which I did seek counsel for that. And they were telling me that, hey, you know what, this date, I told them September 9th. They said they were not available.
Well, you know what? That's not appropriate. Because if they weren't available,
have-
but and they were really intending to represent you, they know what to do. All they needed to do was file an appearance in the case and ask the court for an adjourned date or call co-counsel or adversary counsel and tell them, look, I just got into this. I need a little bit more time. Either they would have agreed or your new lawyer would have filed a motion asking the court to push the date back. So just telling you they can't come, that's not good enough. And they're not representing you.
Right. He did tell me to come to ask the court for the extension because of that.
No,
Yeah.
I'm not doing anything because of him.
Right.
Because he has no standing here. He didn't file an appearance at all or
He's
indicated even by phone call to the court that he was trying to represent you.
It was more than one attorney that I had seen judge.
Okay, well then why didn't you come up with one, Mr. Pullins?
I was waiting for the response to see what was going to be the case for them being available or not. I knew the importance of it, but I reached out a lot of times, you don't get the call back. I had several attorneys I did talk to. One attorney that I did talk to, he said he could represent. However, I told him the name, said we'll go to court anyway and appear. And that was probably one of the attorneys that I was going to call, but he just called the other day.
Well, here's the problem. I don't know why they tell you to go to court anyway and appear, which you should, because you don't want to be defaulted. But other than that, how does that help anything? Because they're not here. Let's just say I would have given you a new date. They don't know what that date is. So then they're going to tell you we can't make that date. The only way we could pick a reasonable date, if we were even going to do that, would be for them to file an appearance and come in here and ask one way or the other by motion or show up on the trial date and ask something. Nobody's done any of that. They're asking you to do it. And me pushing the date back for some unknown attorneys is just, that's ridiculous. We don't know who they are.
The other thing that I did, I didn't mind. I paid, some of the rent too that was need to be paid because of the delay. We're not there just because we just want to start time. It was just about really coming to an agreement with it. Again, I never got the attorney's letter. I still seek counsel immediately.
It doesn't matter. You knew you needed one.
Yes.
She was just doing you a favor, making sure you'd be ready. So if you didn't get it, okay, I get that. I'm not gonna dispute the fact you didn't get it because I know how the mail is around here.
Again, I'm not even concerned about that. I seek counsel because I knew that they said being an LLC, I need to be represented. So I immediately seek counsel. I immediately did it. And so I do have someone in mind that we are hiring.
Your Honor, if I may, at this point, the eviction proceeding was filed we gave Mr. Pullins and VSH notice of instituting the eviction proceedings as of May 13th, 2025. The proceeding was actually filed in June. He owes close to, I think, over $26,000 in back rent, late charges. My client has terminated the lease with Mr. Pullins and his LLC. At this point, we simply want possession of the property, and any further delays prevent us from getting possession of the property.
Yeah, I mean, I agree with you. No one wants to not give people due process, but he's got it. It's not like we set this case, yesterday and said, you better be here and didn't give you a chance to get a lawyer. You had a lawyer with a limited appearance. He told you, I'm limited. Come back with somebody else. Now, if you had someone else and they needed time to prepare, I would be a little bit more sympathetic. I get it. I mean, they show up the last second, and if they're not ready and they needed a very brief adjournment, I might have been able to do that. But you don't have anybody.
So, Your Honor, the amount of money that they said, I did bring proof that I had paid about $32,000 of
Okay,
that.
well, let me say this. If you've already shown that to, council this morning,
No, I have not. I haven't even met with council this morning.
okay, because
Because I paid-
I don't know
paid-
I don't know what the issue is here. They're saying,
I paid the amount that she said that they paid. Melrose Group refunded me supposedly $14,000. I never got it. I got the email for that. I paid about $32,000, maybe $28,000. I bought the proof of the canceled checks of that amount that they said I owe from May up to June. I've always paid what I needed to. I may be late, but I always include the late fees as well. So they refunded me a check for $6,000. So I had assumed that they had overpaid. So that's why I wanted to argue what was the numbers, because my proof is about $28,000 that I had paid, canceled checks. However, they refunded me $6,000, and my previous attorney said that they were supposed to send you $14,000. I never got any of that. So the money that they're saying they owe, I paid that I have canceled checks. So that'll probably
that's what we're here. Listen, if you haven't showed it to them, that's what we're here to determine. Do you owe rent, and if so, how much? And if I make a determination on how much, you get a certain amount of days to pay it. I guess you pay, you stay till the end of your lease.
Well, the other thing
is up.
they
The lease is
terminated the
fake.
lease,
The
which
lease
was
is fake,
fine,
terminated.
but they said that if they terminate the lease, which was fine, I don't have a problem with that, they were going to refund me back that money. I never got that money. I
Well, I don't
already
know.
paid, the $32,000 previously. I paid $35. No, I take that back. I paid about $28,000. Then the previous attorney said, hey, they're supposed to refund you $14,000 back because they are terminating the lease. And
Okay.
so
All right, well, hold on. What about that?
Your Honor, I have copies of ledgers that show the amount that has been refunded of $14,456 to Mr. Pullins, and that an end balance of the amount that he currently owes is $26,503.78. And this is amounts that he has owed, payable on his lease. Then a complete ledger that goes from January of 2023 through through August 22nd of 2025. I can give him a copy of that ledger. I know that he's received it and he reviewed it with his counsel. At this point, the lease has been terminated, and possession of the property is of utmost importance.
I never got any of that money. If they can show that we received a check for that amount, I'm satisfied with that, Your Honor.
Okay,
The
14,456 is
The
what she
previous
said.
attorney told me the same thing. I never got that check. I don't
Okay, but
mind.
she should have a canceled check or something showing it.
That's what I'm saying. I'm paying all this money. They said they were gonna refund me. I know that if I don't stay and they determine they have to give me my money back, they didn't. So that's why I'm like, wait a minute, I'm keep paying all this money into this thing. I didn't get any money back. And the attorney, he asked me, I said, no, I got nothing.
It sounds to me like, Your Honor, Mr. Pullins is willing to vacate the property.
It
And
sounds
then-
like he is too, if you give him his money, which he says he didn't
Right.
get.
I don't have a problem with moving. I never had a problem moving, even when we were trying to negotiate to settle. I was trying to figure out, okay, what do I owe? Because I got security deposit that's there. That wasn't committed. Then they said that they were going to subtract a certain amount from what I owe. I never got any of that.
Well, I mean, right now, this is scheduled as a non-payment of rent case. We can convert it to just a simple termination of tenancy, and you guys can figure out the money part later.
But
And
then,
if in fact money is still owed, they can either sue you for it or you can sue them for it.
so if I go down to court and repeal it, because again, I'm getting counsel, I'm trying to do what I can for that. I didn't expect the other attorney would drop, he wasn't able to handle the trial. They paid me my money, I don't have a problem leaving. But I never got any of that. That's a lot of money. I rehab the whole entire
Well,
building.
she's claiming, is it $14,456 that you're saying, Ms. Williams, that was paid?
I first got a notice that it was $16,000, that they sent me through my attorney and through talking to the attorney. However, they sent me $14,000. I never got any of that money. So that's why I was concerned. Because I keep paying money.
I think the issue is,
You're
Your
good,
Honor,
Mr. Pullins.
if-
Let me just talk to her now. What is it?
I'm looking at the ledger, Your Honor, and after consultation with the client representative, part of the issue is that Mr. Pullins paid, looks like $8,200 in checks, but those checks did not clear. And so I have copies of refunded checks that I could provide to him that shows checks that were refunded. But then there's also that additional amount, and I believe if my math is correct, that will get us to the 14,000 that was refunded to him.
Okay,
Yeah.
Mr. Pullins, well, that's fair.
Why they don't have any canceled checks? Because I don't have any canceled checks.
I have all.
And they said they send me a check, Your Honor. I would want that $14,000.
Okay, Mr. Pullins.
Just saying, if they send me a check.
Mr. Pullins, repeating that 6 or 7 times doesn't change anything. You say you don't know, you don't have it. Let's try to get to the bottom of it. She's saying that some of your checks for $8,200 did not clear. So
Okay.
somehow they calculated and got to the $14,000 amount. Now,
That's not-
if you're good with that, if you believe that's correct, now we need counsel to find the check for $14,000 that you sent him that he cashed.
Correct. That's what I was saying.
So, Your Honor, I have a ledger from the client that shows like all of the returned and checks that did not clear that I could provide to Mr. Pullins, showing all of the amounts. I also provided him with copies of the refunded checks. And then in addition to this ledger, this will show all of the money that he gave to the client that did not clear and so was refunded.
Okay, but well, where's the $14,000 is what he wants to know.
That.
So part of it was he tried to pay rent. That money did not clear with the client. So that was never paid. That's a portion of the money.
Okay,
other
so how much
portion-
does he owe? Do you owe him anything back now is the question.
No, Your Honor, he still
thought-
owes them $26,000.
So the $14,000 would have been a refunded amount had the checks cleared?
No.
Yes, Your Honor, a portion of it, correct.
My attorney, they sent me 2 checks, Your Honor. I sent them back for $6,000. I told my attorney, I said, no, I got 2 checks for $3,000, 1 check for $3,035. I sent that back to them because I thought it was an overpay. He said, well, no, you should have received $14,000. I said, how you get that? I said, I sent them 2 checks back. I even paid money in August because I don't mind paying the money. I've been there over 10 years in the complex. So I sent the $6,035 back to them. I paid money in August to them. I've been paying big money for this place and I rehabbed it. So I don't see the check. That's not true. If a check refunds come back with me canceled, I need to go back into the bank the next day because we did have some fraudulent activity on our account. So items did not pay. I went back to the bank the following day, deposited directly into their account. Here's my canceled checks. I went to the bank and got all the canceled checks, even the checks that didn't.
Sorry, you know what? I'm thinking you guys can show documentation. She says checks that didn't clear. You don't believe that they didn't clear? Is that what you're saying?
Check for $8,000, Your Honor.
Your Honor,
And even if they told them out, I would go to the bank the next day because we had 2 situations on our.
Well, you know what? I can't resolve this like this. I thought you all could show documents. Everybody could agree because, documents not going to lie.
well,
If
we
you
have
want me to look at all these documents, then we got to go to trial and we don't have a lot of time to finish this trial now, but we can start it.
Your Honor, at this point, even if he is owed $14,000, there's still a dispute as to other back rent that he is owing that it's not in dispute at this point. So he's still in breach of the terms of the lease. We've terminated the lease with him. Even if you minus $26,000 minus 14, that would be $12,000 that he is in default. And at this point, because today was the date and time set for trial, Mr. Pullins had notice of that. He's not disputing that additional $12,000. We need possession of the property today, and we do not want this to be continued further.
I paid the $12,000 if they say I have to default.
Your Honor, we do
I
not
paid
want
$12,000.
it in the bank.
They're saying something that I'm not even aware of. My attorney was handling all of this. That's why I hired an attorney. I need an attorney for this. And I'll pay them the $12,000.
Your Honor,
Every time they send me a notice to pay, I pay it.
Listen, if
If
there's,
they give me my $14,000, I'm done.
she says you're not owed the 14 because some of your checks didn't clear.
That's speculation, though. That's not true.
it's not speculation, Your Honor, because there are documents that have been provided to Mr. Pulling showing that the ledger is correct, that there were refunded checks, and that his checks did not clear. He's not disputing that he owes money, that he's in default of the lease, and that he admitted that he would be willing to terminate his lease with my client. At
Well,
this-
you got two options here. We can go to trial and figure out exactly what is due, if you want to do that, or we can convert it to a termination of tenancy, give them their property back, and you all can dispute later the amount of that's still currently due on the lease. That's up to you, however you want to do it.
We're agreeable to the second option, that this is a termination of tenancy and we figure out how much money is due after the fact.
Yeah, and you can still file a separate action. Doesn't wait.
But you know how that goes, Your Honor. You do that, then not gonna get a response, not gonna get the respect that's needed. Avalier sent me a letter saying that they were gonna refund me personally $14,000.
Mr. Fuller, Mr. Fuller, stop. Stop talking, please. I have heard you say that at least 10 times. Telling me yet again doesn't do anything. I get the issue. I'm not deaf. I hear you. Now the question is this. You're not disputing that you owe them some money, are you?
I only owe them for the present months that I was in, but.
That's a yes or no question.
No.
All right. So we know something is owed. The question is how much?
That's true.
So you're not disputing that if you owe money, you would be in violation of the terms of the lease somehow, are you?
No. Because I paid money in August. I paid this August, you know.
I didn't ask you that.
Okay.
I just asked you, are you disputing that you would be in violation of terms of the lease since you owe money?
Yes.
You're disputing that? No.
Okay. I misunderstood.
Okay. So if you're in violation of terms of the lease and you owe money, technically the way the case is scheduled now, it is they would get a judgment for whatever the amount would be and you would have to move because your lease is terminated. So the suggestion is to convert this from a non-payment of rent case, meaning we do not determine the exact amount today. She reserves the right to file a separate case on the issue of how much money is actually due and owing. So these same issues are not decided. They're just put off. And you give them possession of the property by moving. How does that sound?
Your Honor, I would like to have my attorney. Because I don't know. They say I need to be represented. I don't want to.
Okay. First of all, this was the date to have the attorney.
That's correct.
So you are either going to move forward yourself or not. And the not is not an option because you had time to get a lawyer. So I'm asking you, you're going to get a default anyway. So as to the corporation, because there's no lawyer here for them, I'm asking you on behalf of yourself, would you like to terminate this matter today and just whatever you got personally there, move? Doesn't mean you're absolved for any personal liability on the money. And it doesn't mean that if we convert it, doesn't mean that the LLC is absolved from any liability on money. It just means that putting it off till later before you can get a lawyer. You would have another chance to get a lawyer to argue the same issues.
Let's do that.
All right. So
Do I have to terminate from the building till I do that? Or how does
you
that?
need to move out of their premises. What about that don't you get?
No, I'm just being clear.
So what we'll do is I'll have counsel prepare an order, a judgment and we're going to do it by consent, meaning that you're going to sign it now. And we're going to put under number 10 of the judgment, convert this matter to a termination of tenancy in all, and you, if you want to put the language, something about all rights are reserved to determine any amounts due and payable under the lease. And then the writ date. How much time? It's a 10-day period. It would be September 19th to move, sir.
That works for us, Your Honor.
And then if I don't agree to that,
If you don't agree to it.
yes.
Okay, well, then we're going to have a default judgment against the corporation today. And you can try whatever you want today yourself, if that's what you want to do. No lawyer.
So can I get longer than the 19th? Because I have a lot of stuff. It's a big deal.
Counsel, talk to your client. It'll probably behoove you to give him a couple extra days if you want possession.
We could be at the end of the month. Your Honor, we are prepared to give Mr. Pullins till the end of the month, so to the end of September.
September 30th.
If he'll give us access to the building
Absolutely.
within the interim.
I'm willing to do that.
Okay, so we'll convert to termination with rights reserved to determine amount due under the lease. So that might be and you know what? You don't have to file a separate case. You all can still exchange your documents and talk once you get a lawyer. But just know they could file this separate case if you don't get your lawyer.
Yes. Thank you.
And your writ date is going to be September 30th, 2025. And that's going to conclude the case for today. Counsel, you want to go downstairs and get a landlord-tenant judgment, have him fill it out and have him sign it, and then you have to scan it in.
Okay. I can do
And
that.
then, just leave the amount due up there in box 2 blank and check whatever 2B is.
Okay.
And then just say, plaintiff has a right to possession. Writ date is going to be September 30th. No money judgment. And then under number 10, convert to termination tenancy, all rights reserved to determine amount due under the lease at a later date.
Understood. Thank you so much, Judge.
Thank you, Your Honor.
Okay. All right, Mr. Pullins, good luck.
I appreciate it. Thank you.
And that's going to complete this particular matter.
Okay. You can.
Madam Clerk, what else you got?
That's it, Judge.
Okie dokie. So that'll conclude this matter, and I will see you this afternoon.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is a absolute interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. You're going to learn how to act in a corporate.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go so
Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.